Your Honor, I need to stop this proceeding. What I am about to present to this court does not just change this case, it changes everything. The attorney who spoke those words was not young. Margaret Choi was 57 years old, 31 years in civil litigation, and she had developed over those decades the specific quality that the best trial attorneys develop, the ability to say the most devastating thing in the calmest possible voice. She did not raise her pitch. She did not pause for drama. She simply stood at the podium in Courtroom 11 of the Cook County Circuit Court and said what she had to say. And the room did what rooms do when something genuinely extraordinary enters them. It went completely still. The case before Judge Raymond Ellis that morning was a civil malpractice suit. The family of a 47-year-old man named Christopher Vance against one of Chicago's most celebrated cardiothoracic surgeons, Dr. Alan Merritt. Christopher had died on Dr. Merritt's operating table 14 months earlier during what had been described as a routine but high-risk cardiac procedure. His wife, Sandra Vance, had filed suit 6 months after his death, alleging that Dr. Merritt had deviated from the standard of care in ways that had directly caused her husband's death. It was a serious case. A painful case. But it had been, until this moment, a relatively conventional malpractice proceeding, the kind that Chicago's medical community knew and accepted as part of the landscape of high-stakes surgery. Dr. Alan Merritt sat at the defense table in a dark suit, silver-haired, composed, carrying the particular authority of a man who had spent 30 years being the most important person in every room he entered. He was 63 years old. He had performed over 4,000 cardiac surgeries. He had been featured in 3 national medical publications. He had a building at Northwestern University Medical School with a donor plaque bearing his name. He looked at Margaret Choi with the expression of a man who was not accustomed to being surprised. He was about to be surprised. Subscribe to sweet justice right now. Because what Margaret Choi was about to reveal had nothing to do with the surgery that killed Christopher Vance, and everything to do with the man who had been allowed to perform it. Christopher Vance had been diagnosed with a significant cardiac condition 18 months before his death, a structural abnormality of his aortic valve that his cardiologist had monitored carefully for 2 full years, ordering regular imaging, adjusting medications, and watching the data with the patience of someone who knows the moment for intervention is coming but wants to be completely certain before it arrives, before finally concluding, after the 3rd annual scan, that surgical intervention was no longer avoidable. The procedure recommended was an aortic valve replacement, complex, serious, carrying real risks, but a surgery that in the hands of an experienced and qualified cardiothoracic surgeon had a success rate that Christopher's cardiologist had, described as reassuring. The cardiologist had referred Christopher to Dr. Alan Merritt specifically. Dr. Merritt was, in the world of Chicago cardiothoracic surgery, a name that carried weight. His practice at Lakeview General Hospital was considered among the finest in the state. His patient outcomes were consistently above average. He had a waiting list. His consultation fee alone was enough to make most families pause. Christopher and Sandra had not paused. They had taken the referral, met with Dr. Merritt, and come away from that meeting with the confidence that Sandra would later describe in her deposition as the feeling that Christopher was in the best possible hands. The surgery had taken place on a Tuesday morning in April. It had lasted 6 hours. Christopher had not woken up from the anesthesia. The official cause of death documented in the hospital record was intraoperative hemorrhagic complication, a catastrophic bleed that had occurred during the procedure and that the surgical team had been unable to control. Dr. Merritt had met with Sandra that afternoon in a private room and told her, in careful, measured language, that everything that could have been done had been done. That sometimes, despite all preparation and all skill, the body did not cooperate. That he was deeply sorry for her loss. Sandra had thanked him. She had gone home. She had spent the next 4 months in the specific fog of grief that follows a sudden and unexpected loss. And then, in the 5th month, she had met Margaret Choi. Margaret had been referred to Sandra by a friend of a friend, a woman who had used Margaret in a dispute years earlier and described her as the kind of attorney who does not stop pulling a thread once she finds it. Sandra had not been looking for a fight. She had been looking in the vague and directionless way of people who cannot accept that something terrible was simply an accident for an explanation. Margaret had listened to her for 2 hours and then said, "Let me look at the records." Margaret had looked at the records for 3 weeks, working through them methodically in the evenings after her regular caseload, cross-referencing the surgical notes against the nursing documentation and the anesthesia record with the focused attention of someone who has learned over 31 years that the most important detail in a medical record is almost never in the place you expect to find it. What she found in the surgical notes and the anesthesia record and the nursing documentation of that 6-hour procedure were several specific deviations from accepted surgical protocol that her consulting medical expert, a cardiothoracic surgeon from a university hospital in another state who reviewed cases without any connection to the Chicago medical community, had described in his written opinion as below the standard of care. Not dramatically below, not recklessly below, but below in ways that were specific, documentable, and in his professional judgment had contributed materially to the outcome. Margaret had filed the suit. Dr. Merritt's defense team had retained their own experts. The case had proceeded through discovery, depositions, and pretrial motions with the methodical pace of complex civil litigation. By the time it reached trial, both sides had invested enormously in preparation, and both sides believed, with genuine conviction, that the evidence supported their position. What neither side had anticipated was what Margaret had found 3 weeks before trial, not in the surgical record, not in the expert opinions, not in any document related to the Vance case at all. What she had found had come from an entirely different direction, and it had come, as the most significant discoveries sometimes do, because someone who had not been looking for anything in particular had happened to look at the right thing at the right time. Subscribe to Sweet Justice right now if you are not already. Because the person who handed Margaret the thread that unraveled everything was not an investigator, not a whistleblower, and not anyone connected to the Vance case. And what they found when they looked is something that should not have been possible in a modern credentialed medical system. The person was a second-year medical student named James Park, no relation to Margaret, who was completing a research rotation at a university medical library and had been tasked with compiling a database of published surgical case studies from the previous 30 years for a faculty research project. In the course of that work, James had pulled a collection of cardiothoracic surgery papers from a medical journal archive dating back to the early 1990s. One of those papers, a case study published in 1993 under the name of a Dr. A. Merritt, affiliated with a university surgical program in Michigan, had caught his attention not because of its content, but because of a footnote. The footnote referenced the author's board certification year and institution. James, who had recently attended a hospital grand rounds presentation given by the celebrated Dr. Alan Merritt of Chicago, had noticed that the certification details in the footnote did not match what Dr. Merritt had stated in his grand rounds biography. It was a small discrepancy, the kind of thing that could have been a typographical error, a database inconsistency, or simply a confusion between two physicians with similar names. James had noted it in his research log and, on the advice of his faculty supervisor, passed the observation to the university's Academic Integrity Office. The Academic Integrity Office had passed it to their legal counsel. Their legal counsel, recognizing its potential significance, had done something that would later be described as both procedurally correct and quietly extraordinary. They had called Margaret Choi, whose malpractice suit against Dr. Merritt was a matter of public court record, and told her what James Park had found. Margaret had spent 3 weeks pulling on that thread, and what she found when she pulled it was not a typographical error. The credentialing system for medical physicians in the United States is, in theory, one of the most robust verification systems in any profession. Medical schools verify transcripts. Residency programs verify medical degrees. Hospitals verify board certifications. State medical boards issue and renew licenses based on documented training and examination records. Malpractice insurers verify credentials independently. The system has multiple layers, each designed to catch what the previous one might have missed. What Margaret discovered over 3 weeks of investigation, working with a credentialing specialist she had used in previous cases and a private investigator, named Carol Sims, who had spent 15 years tracing professional documentation, was that Dr. Alan Merritt had navigated every single layer of that system using a combination of genuine credentials, strategically altered documents, and a timeline constructed so carefully that no single verification step had ever been in a position to see the full picture. The genuine part was real. Dr. Alan Merritt had attended medical school. He had completed a general surgery residency. He had obtained a valid medical license. He had practiced general surgery for 4 years and built a legitimate, unremarkable record. That foundation was real, and it was his. What was not real was the cardiothoracic specialization. The fellowship training he had listed on his curriculum vitae, a 2-year cardiothoracic surgery fellowship at a prestigious Michigan institution, had never happened. The institution confirmed, when Margaret's investigator contacted them directly, that no physician named Alan Merritt had completed a fellowship in their program in the years listed or in any surrounding years. The board certification in cardiothoracic surgery that appeared on his hospital credentials file had been issued by an organization that, upon investigation, turned out to be a private certification body with no affiliation to the American Board of Thoracic Surgery, the legitimate certifying authority, and whose certificates, while visually convincing, carried no actual professional recognition. Dr. Alan Merritt had been performing cardiothoracic surgery, open heart surgery, valve replacements, bypass procedures, for 26 years without the training or the legitimate board certification that those procedures required. The hospitals that had credentialed him had verified the documents he provided. The documents had looked correct. The certifying body had a website, a phone number, and a staff member who confirmed certifications when called. A staff member, who, it would later emerge, was a woman named Diane Cross, who worked out of a home office in Indiana and who had been issuing certificates for the organization for 11 years without, apparently, any understanding that the organization itself was not legitimate. 4,000 surgeries, 26 years, and not one credentialing review had caught it. Margaret sat with that information for a full day before she decided what to do with it. She understood that what she had found went far beyond her civil case. She contacted the Illinois Department of Financial and Professional Regulation, which oversaw medical licensing, and the Cook County State's Attorney's Office. Both were notified formally and in writing before Margaret walked into courtroom 11 and said what she said. She had not told Dr. Merritt's defense team. She had not been required to under the procedural rules applicable to a civil case where the new information related not to the civil claim, but to a separate and independent set of facts. She had complied with everything the rules required, and she had timed the disclosure for maximum effect, not out of cruelty, but because she understood, after 31 years of litigation, that some truths need to be told in a room where they cannot be walked back. Judge Ellis had called a recess the moment Margaret finished speaking. The recess lasted 2 hours. When court reconvened, Dr. Merritt's lead defense attorney, a veteran civil litigator named Howard Park, had the look of a man who had spent those 2 hours making phone calls and receiving answers he had not wanted to hear. He sat down at the defense table and placed his hands flat on the surface and did not look at his client. Dr. Merritt looked at Margaret Choi. For the first time since the trial had begun, he looked at her with something other than composed authority. He looked at her the way people look at someone who has just shown them the specific thing they spent years making sure would never be shown, not with anger, not with defiance, but with the particular stillness of a man who has run every calculation and found, for the first time in a very long time, that the numbers do not work in his favor. Subscribe to Sweet Justice right now, because what happened in that courtroom over the following 3 days is the part of this case that the medical community in Chicago talked about for years, and the testimony that came next is something nobody in that room ever forgot. The civil trial did not immediately, and when Margaret made her disclosure, Judge Ellis, after consultation with both legal teams during the 2-hour recess, determined that the civil proceedings could continue, that the malpractice claim against Dr. Merritt was a separate legal matter from the credentialing fraud, and that Sandra Vance's family deserved to have their case heard regardless of what else was now in motion. The criminal referral to the state's attorney's office would proceed on its own track. The civil case would proceed on its own. It was the right legal decision. It was also, practically speaking, a decision that placed Dr. Merritt's defense team in an almost impossible position. They were now defending a malpractice claim against a surgeon whose entire specialization had just been revealed as fraudulently obtained. And they were doing it in front of a jury that had heard Margaret Choi's disclosure in open court and would be instructed by Judge Ellis to evaluate only the civil evidence before them. Howard Park made that instruction request. Immediately and forcefully, he stood and said, "Your Honor, the jury has now heard information that is not relevant to the standard of care question before this court. We ask for a curative instruction to be issued immediately and for the court to consider whether a mistrial is warranted given the impossibility of the jury disregarding what they have heard." Judge Ellis looked at him. He said, "Mr. Park, the jury will receive appropriate instructions. The motion for mistrial is denied. The credentialing information the jury has heard is a matter of public court record. The question before this jury remains whether Dr. Merritt deviated from the standard of care applicable to the procedure he performed. That question has not changed. Proceed." Howard sat down. He had not expected the mistrial motion to succeed. He had made it because he had needed to make it, and because making it was the only tool he had left. Margaret called her medical expert, Dr. Susan Rowe, the following morning. Dr. Rowe was a cardiothoracic surgeon with 32 years of experience, board certified by the legitimate authority and faculty at a university medical program with no connection to Chicago's medical establishment. She had reviewed the surgical record, the anesthesia notes, the nursing documentation, and the post-operative reports for Christopher Vance's procedure. She had prepared a written opinion that ran to 41 pages. Judge Ellis said, "Dr. Rowe, you have reviewed the complete surgical record in this case. In your professional opinion, did the care provided to Christopher Vance during his aortic valve replacement meet the standard of care applicable to that procedure?" Dr. Rowe said, "In my professional opinion, it did not." Judge Ellis said, "Can you describe specifically where you believe the standard of care was not met?" Dr. Rowe walked the court through 4 specific points in the surgical record where the documentation reflected decisions that she characterized as inconsistent with accepted cardiothoracic surgical practice. She was specific, she was technical, and she was, throughout, completely clear, translating each clinical point into language that the jury could understand without losing the precision that made the testimony credible. Howard Park's cross-examination of Dr. Rowe was the most difficult work of his career in that moment. He challenged her interpretation of the surgical notes. He argued that the decisions she had characterized as deviations were within the range of reasonable surgical judgment. In a complex procedure, he brought in his own expert, a Chicago-based cardiothoracic surgeon named Dr. Paul Greenberg, whose testimony supported the position that the hemorrhagic complication that had killed Christopher Vance was an unpredictable and unpreventable outcome that could occur even in the most skilled hands. The jury listened to both experts with visible concentration. They took notes. They asked, through a written question submitted to Judge Ellis, whether they were permitted to consider the credentialing information in their deliberations. Judge Ellis's answer was carefully worded. He told them that they were to evaluate the standard of care based on the expert testimony presented, but that they were not required to ignore context that was part of the court record. It was, as legal instructions sometimes are, a sentence that could be interpreted more than one way. Sandra Vance testified on the 4th day of trial. She was 44 years old, composed in the careful way of people who have rehearsed their composure because they know what happens without it. She described Christopher, his personality, his patience with the diagnosis, his confidence in Dr. Merritt after their consultation. She described the morning of the surgery. She described the afternoon when Dr. Merritt had come to tell her that her husband was gone. She described the 14 months since. Margaret asked her one final question. She said, "Mrs. Vance, if you had known before the surgery that Dr. Merritt did not have legitimate board certification in cardiothoracic surgery, Would you have allowed him to operate on your husband? Howard Park stood immediately. He said, "Objection, Your Honor. Speculation. Calls for a hypothetical." Judge Ellis said, "Overruled. The witness may answer." Sandra looked at the jury. She said, "No, I would not have. We trusted him because we believed he had earned the right to be trusted. And he had not." The jury deliberated for 2 days. They sent out 3 questions. The first asked for Dr. Rowe's testimony on the 4 specific deviations to be read back in full. The second asked for clarification on the legal standard for medical malpractice in Illinois. The third asked whether the credentialing facts presented in court had been verified by an independent authority. Judge Ellis answered the third question by informing the jury that the Illinois Department of Financial and Professional Regulation had suspended Dr. Merritt's medical license the day after Margaret's disclosure, and that a criminal investigation was ongoing. He told them this was a matter of public record and that they could weigh it as they saw fit in assessing the overall context of the case. Howard Park did not object to that answer. He had run out of objections that mattered. The jury returned on a Thursday afternoon. The foreperson, a woman named Ingrid Moss, a retired hospital administrator who had taken detailed notes every day of the trial and who had, it would later emerge, spent the second night of deliberations reading the Illinois Medical Practice Act on her phone, stood and read the verdict. On the claim of medical malpractice resulting in the wrongful death of Christopher Vance, we the jury find in favor of the plaintiff. Sandra Vance closed her eyes. On the question of damages, the jury awards compensatory damages in the amount of $4,200,000. Margaret placed one hand briefly on Sandra's arm. Judge Ellis thanked the jury. He dismissed them. He looked at Dr. Merritt for a long moment before he spoke. Then he said, "Dr. Merritt, the civil proceedings in this matter are concluded. I would remind you and your counsel that separate proceedings are now underway in another jurisdiction, and that this court's ruling today is without prejudice to those proceedings." Dr. Alan Merritt was indicted by the Cook County State's Attorney's Office 11 days after the civil verdict. He faced charges of fraudulent misrepresentation, obtaining financial benefit by deception, and aggravated battery by means of conduct likely to cause great bodily harm, the last charge applying to the performance of surgical procedures without legitimate qualification. The criminal trial took place 8 months later before a different judge in a different courtroom with a different jury. He was convicted on all counts. He was sentenced to 14 years in federal prison. His medical license was permanently revoked. The building at Northwestern with his donor plaque was quietly renamed Lakeview General Hospital, where Christopher Vance and hundreds of other patients had been operated on by Dr. Merritt over the course of 11 years, retained independent legal counsel and conducted a review of every surgical case he had handled within their facility. That review identified 31 cases where outcomes had been materially adverse and where the hospital determined that its credentialing process had failed to perform the independent verification that might have caught the fraud. The hospital reached settlements in 22 of those cases. The total value of those settlements was never publicly disclosed. James Park, the medical student whose research log notation had started everything, graduated the following year. At his graduation ceremony, Sandra Vance sent him a card. It said, "Only, thank you for paying attention. Christopher would have wanted you to know that it mattered." Margaret Choi retired 2 years after the Vance verdict. At her retirement dinner, a colleague asked her to name the case she was most proud of in 33 years of practice. She did not hesitate. She said, "The one where the most important evidence had nothing to do with the case I was hired to win." She was asked to explain what she meant. She said, "I was hired to prove that a surgeon made mistakes. What I found was that he had no business holding a scalpel in the first place. Those are 2 very different things, and only one of them was going to protect the next patient. There was no next patient, not for Dr. Alan Merritt. The courtroom had made sure of that. That is sweet justice at its most complete. Not just the verdict, not just the damages award. The moment a system that had failed for 26 years was finally forced to see what it had been missing, Because one attorney pulled a thread, a student noticed a footnote, and a woman who had lost her husband refused to accept that his death was simply an accident. Subscribe to Sweet Justice for new courtroom stories every day. Share this with someone who needs to hear that paying attention still matters. Hit that bell and stay with us. We will see you very soon.